profession long enough to know not to get between lawyers and the bar. So those of you that are in line, stay in line and get your refreshment and then find a seat. But I'll go ahead and start. We're going to have a talk tonight by me on the Constitution and the Supreme Court. And then immediately after that, you're going to hear from the Smolla Band and his 3 band members from Brooklyn to entertain us. And I'm going to sing a little bit with the band and teach you a few songs, and so you're going to have to be in good voice. If you think going to the bar will help you with that, go ahead. Don't be shy. So I'm going to begin with a story. It's actually a famous story. It's a famous debate. And it's a debate between a doctor and an engineer and a lawyer. And the subject is, what is the world's oldest profession? Some of you are thinking something else is the world's oldest profession, but this story will set you straight. So the doctor, who is quite devout, quite religious, she says, well, clearly, medicine is the world's oldest profession. Surgery is the oldest profession, because the book of Genesis said that God reached into Adam's rib, and from Adam's rib created Eve. And so God was first a surgeon, and medicine is the oldest profession. The engineer said, I'm not a religious person, she said, but I've got you. I've got one up on you, because I'll use the same text that you used, the book of Genesis. And it says, before there was Adam and Eve, out of the chaos, God created the heavens and the earth. And so God was an engineer, and therefore engineering is the oldest profession. And the lawyer listened, and she got that smug, self-satisfied look on your face when she knows she's won the case. I think we teach that in legal advocacy here. And she said, okay, yeah, I get it. The chaos, I get it. And God made the heaven and the earth. I rest my case. Lawyers are the oldest profession. Who do you think created the chaos? Well, some of you may think that the Supreme Court of the United States plunged American law into chaos in the last term. I'm going to talk to you a bit about that term, about some of the cases, but I'm going to talk to you more deeply about what could be a real sea shift in the way we approach American law, not one that I think is particularly welcome. So the 3 cases that I'll talk about are the Dobbs case, that's the case that overruled Roe versus Wade. The New York State rifle case, that's the case that said that New York could not keep guns off the streets of New York. And West Virginia versus Environmental Protection Agency, the case in which the Supreme Court largely eviscerated the efforts of the EPA to deal with climate change. Now you may be thinking, well, what does abortion and guns and climate change, what do they have to do with each other? Those seem like very different aspects of American law. But my suggestion to you is that they are united in the jurisprudence the court applied. Its approach to being a Supreme Court justice, its approach to interpretation of law. And in all 3 cases, you see this Supreme Court opting for what I'll call a very static conception of American law, and rejecting any kind of dynamic approach to the interpretation of American legal principles. Now, when I say static, what am I talking about? Well, really one specific idea. If you think about it, most Supreme Court cases involve the interpretation of some kind of text. Either the Supreme Court is interpreting the Constitution, it's reading words in the constitutional text and talking about their meaning, or very commonly it's interpreting a federal statute, or perhaps an administrative regulation. But almost all Supreme Court cases involve some interpretation of words written by somebody from often long ago. And the new approach to interpretation that the court seems to be embracing is to say, here's what our job is. Our job is to think through how the people who wrote those words would have decided this case in front of us at this minute. And typically, that means if it's constitutional interpretation, the court is going to say, how did the people who wrote the basic Constitution and the Bill of Rights in that period 1789 to 1791, how would they have resolved the problem we have in front of us today? Or it involves the question, how would the people who drafted the Civil War amendments, the 13th, 14th, and 15th amendments, particularly the 14th amendment, how would they have solved the problem we have in front of us today? 14th amendment was ratified in 1868. And moreover, as they think that through, what they commonly do, what the court is now commonly doing is saying, the best clue as to how they would have decided today's case is to look at what was going on back then and whether they would have allowed it or not. And if they would, then it's not unconstitutional. And that's what our task has become essentially. And the court has done the same thing recently. I'll argue to you in a little bit that as dense and as technical as the West Virginia versus EPA case is, it largely boils down to a very similar pattern of thought, looking at what the Congress would have done had they had this problem in front of them when they passed the Clean Air Act and deciding the EPA cannot do what it wants to do. So I'm going to talk a little bit about the cases and to kind of demonstrate to you how this has played out. Let's first take the Dobbs case. Now, in the opinion by Justice Alito overruling Roe v. Wade, he begins with the text. And he begins with the text in what is really a very sarcastic, mocking tone. He says, Roe was remarkably loose, that's a direct quote, remarkably loose in its approach to the constitutional text. And then in really what is kind of a snide passage, he says that looseness was characterized by citing all different parts of the Constitution as the parts in which the right to abortion purportedly resided. And he mentioned the First Amendment, and the Fourth Amendment, and the Fifth Amendment, and the Ninth Amendment, and the 14th Amendment. And that was purposefully mocking, to kind of say there was a sort of roving uncertainty as to what the text even was. And then comes the real clinchers. He says, well, not only is the word abortion nowhere to be found in the Constitution, but even the right to privacy is not to be found anywhere in the Constitution. Remember that, I'll come back to that in a minute. And then he says, we have not held that you must be mentioned in order to be recognized as a right, but we have said that for the right to exist, if it's not explicitly talked about, it's got to be deeply rooted in the nation's history and traditions. But when he says that, he means deeply rooted as of the time period we're talking about. So abortion had to be deeply rooted in the country's traditions, a right to abortion, right after the Revolutionary War. Or had to be deeply rooted in the constitutional traditions after the passage of the 14th Amendment. And of course, if that's the way it works, Roe v. Wade has got to be overruled. Because of course there was no right to abortion in the 19th century. Of course there was no right to abortion at the time of the framing. And so if it's that simple, it's game over. And on that basis, Roe v. Wade is overruled. Now, it's interesting, if you adopt that theory, a large part of American constitutional law as we now know it would be vulnerable. Indeed, the entire right to privacy and all of the things that emanated from the original privacy decision in Griswold versus Connecticut would be vulnerable. Most importantly, all protection of LGBTQ rights and the Obergefell decision creating a constitutional right to same-sex marriage. Because none of those are deeply rooted in the history and traditions of the country. Now, there is a passage in the opinion in which Justice Alito says, we're only deciding abortion, we're not deciding anything else. But the theory is there. And if that methodology is used, all of those other rights remain vulnerable. So now let's turn to guns. When we look at guns, we do have a text, the Second Amendment. So unlike the abortion problem, where there's not even a clear textual angle, at least there is. The Second Amendment, you may remember, is a somewhat strangely constructed sentence. The security of a free state, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. I typed that today in Word, and the grammar check dude did not like it. And it has often been criticized as a peculiar phrasing. It's all one sentence. There's this opening passage about the militia being important to the security of a free state, and then there's the second part that says the right to bear arms shall not be infringed. Now, imagine that James Madison, Jemmy to his friends, that was actually his nickname, Jemmy. Imagine he had our modern word processing and grammar check. And imagine someone said, you know, maybe we could word this a little bit better to try to convey your meaning. But of course, he didn't. He didn't have our automated grammar checks, but they had editors. And Madison was generally an elegant writer. So let's imagine I had the honor of being James Madison's editor. He shows me the draft. I'd say, Jemmy, can I call you Jemmy? What's the thought you're trying to convey here? What is it that you're trying to say? Now, I am pretty confident I know exactly what he would tell me, and I'll try to prove that to you in a second. Here's what he would say. He said, we fought a war against King George and England and their standing army with those fancy red coats and everything. We don't like standing armies. Standing armies have been the bane of Europe. Kings and potentates have used them to kill people over and over again. How did we beat the British? With ragtag militia. Farmers and merchants and ordinary folks that were essentially a guerrilla war band. Loosely organized. Volunteers that came to fight for the most part under George Washington. Now, we won the war, but we didn't forget our suspicious of standing armies. We agreed that the United States could have a standing army. We gave Congress the power to create an army and a navy and to regulate the armed forces. We made the president commander-in-chief, but we were very uneasy with the situation. And we thought militias remained an important kind of grassroots way to defend yourself against tyranny. Now, the Constitution also allows the federal government to regulate militias. It's really interesting. The framers spent a lot of time on this. But there seemed to be an oversight. When the Constitution was proposed, there were a lot of things people thought were missing. That's how we got the Bill of Rights. And one of the things that a lot of folks did not like was the fear that the central government in D.C., of course it wasn't D.C. yet, that the central government could abolish the militias. And they didn't want that because the militia to them was a kind of guarantee of freedom when push came to shove. And so to get the Bill of Rights passed, many states insisted there be a militia protection. And all they were asking for is it be explicitly said the United States government cannot abolish the state militias. That's all they meant. And that's what Jemmy Madison would say. He would throw in this as a kind of second thought. He would say, oh, and by the way, I don't think people should be forced to serve in the military against their religious scruples. He would say that too. So if I were working with him, I'd say, okay, I got this. Let's try a new wording. What about something like this? Congress shall make no law infringing the power of the states to regulate and arm their own militias. And I'd like to think he'd say, yeah, I like that, you know. And I'd say, you know, if you think about it, your First Amendment's really well worded. It's nice declarative sentence, right? Congress shall make no laws respecting an establishment of religion, abridging the freedom of religion, or the freedom of speech. Nice. So we'd have two back to back. Congress shall make no law abridging, Congress shall make no law infringing, and everybody would know what was meant. But I wasn't there. And we got the Second Amendment that he wrote, which set up the first great battleground case in 2008, Heller versus District of Columbia, in which two of the great legal minds of the last century, Antonin Scalia and John Paul Stevens, battled. And they both agreed the answer to this should be history. Justice Scalia's version of history was a little fast and loose in my view. He first pulled off a brilliant trick. He said, you read the Second Amendment, that first part is the prefatory clause, and the second part is the operative clause. That's clever lawyering, because once you call something prefatory, you're saying it doesn't really matter. And the only thing that matters is the second half. So he reads it as if it says, the right of the people to keep and bear arms shall not be infringed. That's the way he reads the Second Amendment. Justice Stevens, in dissent, I thought persuasively said, you are not being faithful to history. You're not being faithful to the text. The most natural meaning of the text is, the whole point of this is to protect the militia. But even if you and I are going to squabble over the use of the English language and your stuff about prefatory, how do I know you're wrong? Because I saw the first drafts that James Madison wrote, because they're available. And the first drafts are exactly what I described to you in my pretend interview with James Madison. The first draft made it very clear. It came from the Virginia resolution, made it very clear. It's to protect the state militia, because we think militias are important to a free people, and nobody has to serve if it's against their religion. He honed it down, we got what we got. It turned out it became vulnerable. So in Heller, the Supreme Court says it really is an individual personal right to possess a firearm, at least in your own home, as a right of self-defense. In the most recent case, New York State Rifle, the court said it's more than that. It's not just a right to have the gun in your house, it's a right to carry the gun through the streets and parks of New York. It's a right to be out in the public with your gun. Now, I'm going to leave this in a second. The holding is not as interesting to me as the methodology. If you read the opinion by Justice Thomas in that case, he blows away a giant part of modern American constitutional law. So the main toolkit, one of the biggest things we have, those of you that are second and third year students know this, third year students, get this down for the bar exam, okay? First year students, you're going to hear it. A giant part of constitutional law involves a thing we call ends means analysis. We ask the government, what are you trying to accomplish? How important is this? And then how well tailored is your law to get to that goal? And there are things called tiers of scrutiny, more than folks need to know. But it goes from the highest level, strict scrutiny, where we require the government to have a compelling reason for what it's doing, to a middle level, we call it intermediate scrutiny. The government has to have a substantial interest or an important interest. And then the lowest level, where the government can basically have any interest it wants, and the court always says the government wins. Well, in the aftermath of the Heller case, hundreds of lower courts had to deal with gun issues. And they did the most natural thing. All of them did. They said, well, we'll borrow from this toolkit. This has been around for 50, 60 years in constitutional law. And we'll apply these levels of scrutiny to these gun rules, and we'll see if the government's got a good case or a bad case. The lower courts in the New York case said, you got a real good case. You got a very good case based on social science data that New York is safer without people having guns. Now, it's true, if you have your gun and a bad guy comes after you, you can shoot him down in self-defense. So a lot of people think it's safer to have the gun, but New York made a very strong case. No, actually, At least in big cities, you're better off with a largely disarmed population. Here's the fascinating thing about the opinion in Dobbs. Justice Thomas for the court says, we ain't going there. We're not going to use means, ends, and analysis. We're not going to ask New York if you got a good case. We're not even going to let New York make a case. Here's what we're going to do. We're going to ask, would this sort of regulation have been allowed by the people who wrote the Second Amendment back when they wrote it? Would they have said it's permissible to keep people from wearing and carrying guns down dirt roads and through the rutted streets of New York? And Justice Thomas says, of course they wouldn't have said that. People had guns, they carried them all the time. And they wouldn't have thought that was a permissible form of regulation. Game over. Game over. Well, this has profound effects beyond just the approach in this case to the Second Amendment. Because what Justice Thomas said about the Second Amendment could be said about any constitutional guarantee. It could be applied to religion, and the court has tended to apply history to religion more and more recently. It can be applied to free speech. Here's the proof. Justice Thomas and Justice Gorsuch are on a crusade to have overruled one of the most famous free speech cases of all time. A case called New York Times versus Sullivan from 1964. It's a case that created the actual malice standard. If you're a public official and you sue somebody for defamation, you have to show that it was made, the statement was made with knowledge of falsity or reckless disregard for truth or falsity. This was, if you followed Johnny Depp and Amber Heard, this is the battle that they have, okay? Modern defamation law. Justice Thomas says, throw the whole thing out. Because we know for sure, at the time the First Amendment was enacted, they had all kinds of libel laws. Heck, I mean, it was even worse than that. You know, Aaron Burr shot Alexander Hamilton. People did, you know, the reputation was everything, and people sued each other all the time for this. They wouldn't have never stood for this rule. So it has the possibility of creeping well beyond just the Second Amendment. Now will come, last case, the West Virginia case. A technically difficult, intricate environmental law decision, but it boils down to something fairly simple. At the end of the day, the majority in the case says, you can't point to anything in the text of the Clean Air Act that empowered the EPA to get into the business of regulating energy and to get into the business of cap and trade, to get into the business of trying to move energy away from carbon dioxide creating sources to sources that would not accelerate global warming. And because you can't point to that, and because this is such a big decision, the agency has violated its authority, and we strike it down. Now you may think, well, that's different, that's administrative law, that's statutory law, but it's really a very similar thought pattern, I think. He's basically saying, Chief Justice Roberts for the court here, Congress would never have envisioned this when it passed the Clean Air Act. You, the EPA, cannot get away with it now. You want to get this done, get Congress to enact it, but you can't think that you have this free rein. There is a stirring dissent in the case by Justice Elena Kagan. And in a very powerful message, when me and the band sing it a little bit, you'll get a little resonance of it. She says, you know, we have been delegating broad authority to administrative agencies for decades and decades and decades and decades on giant decisions, and for good reason. Congress can't anticipate science, can't anticipate technology. Congress knows it doesn't have the expertise in a lot of these areas. It passes something with a general value, and then it says to the administrators, you run with the ball. And then in a powerful, powerful resonant ending, she says, this is how the modern nation has been built. The whole country has been built on rules that have been progressive and made us safer and made us healthier, based on broad delegations to administrative agencies. So I'll end with the potential counterpoint. If I am saying I'm not so sure I'm sold on a static constitution. I think we would be better off as a country with a dynamic constitution, more attentive to change. How do I avoid the critique that that is soft, weak, touchy-feely, and it's not law? Because after all, we think of law as somebody writes some stuff down, it gets passed, and then that's the rule of the game until you change it. And so the critique has always been, you living Constitution people, you're just trying to enact your social agenda through the courts because you can't get it done through the democratic process. And it's illegitimate, it's not law. Here's the counter. And it involves a dichotomy that I'm going to make between the conception and the concept. And here's the notion. When people write laws, yes, they have a subjective conception as to how it's going to be applied in their day, in their time. And there are things they're used to. And they tend to think, well, what I've just done is not going to change what I'm used to. So that might be what's in their brains or in their hearts. But what's the idea that they enacted? What's the concept that they enacted? The concept could be something more important with broader implications than they're able to see in their own time. So the greatest American example of this, of course, is Thomas Jefferson, who owned slaves and exploited slaves. That was evil. Yet he could write, we hold these truths to be self-evident, that all men are created equal. Well, his conception was terrible, but the concept was good. And a subsequent generation of Americans would see the goodness in the concept, eventually. We're not there yet, but we're going there. Think of the people that passed the 14th Amendment, guaranteeing the equal protection of the laws. It was beyond their conception that applied to women. They wouldn't let women practice law. The Supreme Court in Bradwell versus Illinois said there's no equal protection right to practice law. That's a man's job. My goodness, let alone would they have dreamed it would come to protect LGBTQ members, beyond their conception. But the concept of equality had enough compass to it that we could eventually see as a nation through people like Ruth Bader Ginsburg. Yes, it does apply to a wide range of people that are now being brought to the table. The concept can be larger than the conception, and subsequent generations can see it more clearly. You know, like the reggae song, I can see clearly now. Or like Amazing Grace, I once was blind, but now I see. And the greatest example of that in our lifetime was the Obergefell decision, the same-sex marriage decision, where courageously Justice Kennedy says, in that opinion, it is the nature of injustice that we often cannot see it in our own times. An ability to have a dynamic conception of interpretation that is legitimate. I'll give you one other interesting example, so you won't think I'm just railing against conservatives on the court. Because there are conservatives on the court that at times have bought into this notion. And in what I think was a very courageous decision and beautifully written decision, Justice Neil Gorsuch, in an enormously important statutory case interpreting the Civil Rights Act of 1964, said that the prohibition on discrimination against sex includes a prohibition on discrimination based on sexuality, based on whether you are gay or lesbian or a trans person. And he very, very articulately said, I know that in 1964, when the members of Congress passed that law, they never dreamed it would apply to sexual orientation. My goodness, to be homosexual was a felony still in most states in the United States. The first law prohibiting discrimination based on sexual orientation did not come into existence in the United States till 1972 in Wisconsin. He says, I know that, but it's not what was in their brains, it's the words they enacted and the meaning of those words. And he said in a beautiful demonstration, almost kind of a mathematical demonstration, all sexual orientation discrimination is automatically sex discrimination. And here's how he demonstrated it. And I'll be ending with this. Here's how he demonstrated it. He said, let's imagine two employees in the workplace. A man and a woman. We'll call the man John, we'll call the woman Mary. Both are married. Mary is married to a man named Peter. John is also married to a man named Peter. Mary keeps her job, John loses his job. It's the sex of John that made him lose his job. Therefore, you can't have sexual orientation discrimination without having sex discrimination. Now, that was a courageous decision from a conservative appointee, but one that I think followed the better way to approach interpretation. So let me end by this, particularly for the students. Don't despair about the chaos. We've been through this before. What I want you to do is realize you're part of a community, as everyone in this tent is part of a community. A school that has spent its entire existence on trying to do good for the world, trying to improve the environment, trying to engage in justice reform, trying to explain to people the benefits of restorative justice. The whole school has been built on the notion that we live for something bigger than ourselves. And it will be your generation that will be there to convince more of the people that decide these cases to show fidelity to the concept and to the values and not be mired in a historical, static view. In a minute, you'll hear from the band, and the lead singer is my son Dylan, who's named after two Dylans, Bob Dylan and the great poet Dylan Thomas. So let me leave you with these exhortations. As Dylan Thomas wrote, do not go gentle into that good night. Rage, rage against the dying of the light. And for those of us who believe we stand for something, gather strength from the old spiritual. We will not be moved. Like a tree standing by the waterside, we will not be moved. And finally, in the words of the prophet, none of you rest easy. None of you be satisfied until justice shall roll down like waters and righteousness as a mighty stream. Thanks for coming, folks.